So we have looked at the basic outline of a trust, which is usually there is a settlor, the person who created the trust, transferring trust property or setting up a trust where he's named the trustees and he's named the property and he's also named the beneficiaries. So the trustees hold the trust property on trust for the beneficiaries, and if you remember, the trustees hold the legal title of the property, and whenever there's a trust, the legal and equitable title of the trust property separates. So legal title lies with trustees, but the beneficiaries have the beneficial or the equitable title. So we're looking today at constitution of trusts. For a trust to be enforceable by the beneficiaries, it must be completely constituted. Some textbooks call this completely and incompletely constituted trust, the title to this topic. It means it's the same thing, yeah? So that sentence, for a trust to be enforceable by the beneficiaries, it must be completely constituted, has a couple of technical terms. The first is enforceable. What does enforceable mean? Enforceable mean that the beneficiaries are able to go to court and apply and be granted the equitable remedy of specific performance. Specific performance on whose part? On the settlor's part, that the settlor will do what he promised to do when he set up the trusts. But in order for the beneficiaries to be able to do that, the trust must first be completely constituted. So in order for a trust to be completely constituted, the settlor must have vests the trust property in the trustees. To vest trust property in trustees means to transfer the legal title of the trust property to the trustees. And we will look at the different methods of transferring legal title to different types of property later on in this lecture. If the trust property is not vested, then the trust is said to be incompletely constituted, and we will look at what happens if the trust is incompletely constituted. But if the settlor had transferred the legal title, and he's done so using all the proper formalities, then the trust property will now have passed to the trustees, and the trustees will hold the legal title. This trust is said to be completely constituted. Now, incompletely constituted trusts. If the settlor had not vested the legal title of the trust property in the trustees, are the beneficiaries entitled to anything? What are they entitled to? Well, if the beneficiaries have not provided consideration, then they're deemed to be volunteers, because that's what volunteers are. Well, the term volunteer is a technical term. A volunteer is someone or anyone who has not provided consideration. And if the beneficiaries have not provided consideration and they're volunteers, then the maxim that the court will apply is that equity will not assist a volunteer to perfect an imperfect gift. So let's set an example to this. So let's say the settlor had entered into a covenant with certain trustees. He and some trustees signed a deed, let's say, where the settlor says, I promise to transfer my house on trusts for the trustees to hold for A, B, and C. A, B, and C being the beneficiaries. Okay? Right. So the settlor and the trustees have signed this deed. And in the deed, the settlor had promised to transfer the house for this trust. But the settlor hasn't done so yet. Right. So if the settlor then changes his mind, because when I say the settlor covenanted, a covenant is a promise in a deed. So the settlor and the trustee signed the deed with this promise, where the settlor promises to transfer the house. If the settlor later changes his mind, he decides he doesn't want to transfer the house for the trusts, are the beneficiaries that he's named under this trust, A, B, and C, are they entitled to enforce the trust? What does that mean? It means, are they entitled to go to court and ask for an order of specific performance? Well, the maxim is, equity will not assist or volunteer to perfect an imperfect gift. This is an imperfect gift in the sense that the trust has not been completely constituted. Why? Because the settlor had not transferred legal title of the property to the trustee, so the title hasn't been vested, which means it's an incompletely constituted trust. Hence, it is an imperfect gift. And if it's an imperfect gift, the beneficiaries are now asking equity, can you please grant an order of specific performance, forcing the settlor to do what he or she promised? Will equity grant them this order of specific performance based on the maxim? No. Why? Because the beneficiaries in this particular scenario had not provided any consideration for the settlor's promise. So equity will not assist or volunteer to perfect an imperfect gift. Now, if, however, the beneficiaries have provided some sort of consideration, there are equity recognizes other forms of consideration other than money or money's worth, and we will look at what these are later. Then they are no longer volunteers, because if they have provided consideration, something that's accepted in equity as consideration, then they're no longer volunteers and they can enforce the incompletely constituted trust, meaning they can go to court, ask for an order of specific performance. Once this order has been granted, then the settlor will be forced to transfer the house, going back to that scenario earlier, to the trustees. And once the legal title of the house has been transferred to the trustees, the trust becomes completely constituted, and the settlor cannot now go back on the trust. He can't get the house back, because once the trust has been completely constituted, the house, the trust property, no longer belongs to the settlor. It now belongs to the trusts, and the trustees will hold a legal title for the benefit of the beneficiaries A, B, and C. Okay, why? The maxim is, equity deems as done that which ought to be done. So if they've provided consideration, then equity deems as done that which ought to be done, which is the settlor promising to transfer the house to the trust, and therefore an order of specific performance will be granted to achieve that promise. Okay, so far the scenario I've given you is where the settlor has appointed other people to act as trustees. That doesn't always have to be the case. The settlor can himself or herself act as trustee. The settlor can declare himself or herself a trustee holding on trust for beneficiaries. So, for example, if the settlor, let's say the settlor is a grandfather, he has some shares and he wants these shares to benefit his grandchildren. His grandchildren are still minors at this stage, so he knows he can't transfer the shares directly to them. So what he can do is he can declare himself a trustee holding the shares for his grandchildren, the beneficiaries. So all he'll have to do is say, I declare that all my shares in, BT PLC is to be held on trust for all of my grandchildren. Let's say he has 4 grandchildren at that stage. It will be held for them. Okay, now by doing this, once he's declared these trusts, then remember that mental exercise, anytime a trust is declared on any property, what happens? The legal and the equitable title diverge. So if the settlor is declaring, if this grandfather is declaring himself a trustee of all his shares in BT, then once he's made that declaration, the legal title of the shares remain with him. Why? Because he has made himself a trustee, and as we know, the trustee holds the legal title of trust property. So the legal title of those shares remain with the grandfather. However, the equitable title, which has now been separated from the legal title on declaration of this trust, will pass to the beneficiaries, in this case, his grandchildren. Okay? Now, in this instance, the example I gave you of the grandfather declaring himself a trustee of those shares for his grandchildren, this is an example of a completely constituted trust. Why? Because the legal title is vested in the trustee in this case being the grandfather. So there was no need for the grandfather, because he didn't appoint someone else as trustee, there was no need for the grandfather to ensure that the legal title of the shares had been vested in these other persons, because he made himself a trustee, so he already holds the legal title of the shares. The only thing that will change is, as soon as he declares this trust, the equitable title is separated from the legal title and it passes to the beneficiaries. So the legal title is vested in the grandfather already. So these sort of trusts where a settlor declares themselves as trustee is automatically completely constituted, which means if the grandfather now decides, I don't want my grandchildren to have these shares anymore, the grandchildren will have every right to enforce the trust. How? By applying for an order of specific performance to force the grandfather to hold the shares on trust for them. Why? Because if the trust is completely constituted, then it is enforceable. It is valid and it's enforceable by the beneficiaries. Okay? That's the first method on how a settlor can create a trust, by declaring themselves as a trustee. The second method is the one that I've already given you in earlier examples, which is to transfer the trust property to trustees to hold for the beneficiaries. And once the legal title had been transferred to the trustees, then the trusts, they've vested the legal title in the trustees, and the equitable title obviously goes to the beneficiary. Okay? So the trust is only completely constituted provided the settlor had vested the property in the trustees. So vesting is a legal term. It means to transfer legal title to the trustees. So before we look at case law, we need to look at the different methods of benefiting a beneficiary. So if someone has property that they want to give to another person, they want another person to benefit from, how do they do it? Well, the first method is straightforward. You just transfer the property to them. So donor transfers property to the donee or to the beneficiary. This is a straightforward transfer. It means, let's say I have some shares, I'm transferring it to you. So what I'm doing is I'm transferring both legal and equitable title. Everything passes to you. So once the transfer is done, I no longer have the shares, you do. You are the full owner, the sole owner of those shares. Same with, I have a house, I want you to have it. I make sure that I follow the formalities. I transfer the house to you. Once the transfer is done, you have full control. You have both the legal and the equitable title. They're not split at all. That's a straightforward transfer, okay? And it is, well, you know, in layman's term, it's a gift. I've given you the shares, I've given you the house, I've followed the formalities, I've transferred title to you. You become sole owner. The next two methods we have already looked at. The second method is the settlor creating a trust, appointing trustees, vesting the title of the property to the trustees to hold for beneficiaries. So the settlor has set up a trust whereby he has appointed trustees, he's named the beneficiaries, and he transfers title to the trustees. Once he's transferred title to the trustees, the trust is completely constituted and he can't take the property back. The final method, the third method, is the settlor making himself the trustee. So he has property that he wants to be held on trust, so he declares himself as a trustee, and he names the beneficiaries. Once he's done that, as we know, title, the legal and equitable title splits. Legal title remains with the settlor, equitable title passes to the beneficiary. And that's the second way of creating a trust, but the third method of how to benefit someone. Okay? Now, what if, looking at the facts, it's quite clear that the settlor or the donor had intended to make a gift of that property, but for some reason, the gift was void because the donor had failed to comply with the formalities. What happens then? Well, if what was intended was a gift, but somehow title hasn't passed because formalities hadn't been complied with, then what can the donee do? So let's say the donor says, right, I want to give you my shares. And then all the donor did was to pass the share certificates to the donee, say, you can have my shares. Here are the share certificates. Now, that's not enough. As we'll see later, in order to transfer legal title to shares to someone, you need to complete share transfer forms, send it to the company for the company to register the new owner's name and so on. So if all the donor has done to the donee is, oh, I have some share certificates here, 100 shares in British Gas, for example. Here, you have them. Okay, now, donor hasn't actually transferred title because the donor hadn't complied with the formalities. So the donee has these share certificates, but the donee is not actually entitled to the shares. There was a gift intended, but the gift was void, was imperfect, because the formalities to transfer title had not been complied with. So is there anything that the donee can ask equity to do for them? Can the donee ask equity, go to equity and say, can you help me? There was an attempted straightforward gift, but it's imperfect. Can you instead, let's say, treat this scenario as the donor declaring themselves as a trustee holding the shares on trust for me? Okay, so just to recap, the donor has some shares, decides to give it to the donee, gives the donee the share certificates. So it looks like a straightforward gift. That was what the donor intended, to give the shares, but they hadn't followed the formalities. So this gift was imperfect. So the donee here, they really want the shares. So is there anything that equity can do to help? So maybe the donee can ask the court, well, can you treat this scenario not as an outright gift, which was imperfect, but treat it as if the donor had intended to declare themselves as trustee, holding the shares on trust for me, the donee. That won't work. Why? Because the donee in this case was a volunteer, right? They had not provided consideration. So if they've not provided consideration, do you remember the maxim? Equity will not perfect an imperfect gift. Equity will not assist a volunteer. Let's look at a few cases as illustration. First case is Jones and Locke. In Jones and Locke, a father had been away on a business trip, and then when he returned home, his wife told him off for not getting a present for his baby son. So he had been, there was a check that was written out to the father from his employer. So he took out his check, he waved it, and he says, this is for baby. This is for my son. Okay? Now, he didn't do anything else. He gave the check to the baby. Baby started putting the check in its mouth, so he took it away. And he didn't do anything else with the check. So he didn't endorse it in the baby's name. He didn't open an account in the baby's name and place the check in the account. He didn't do any of that. So when he died later, the check was still in his safe with all his other papers. Okay, so there was an imperfect outright gift. So from the facts, it looked as if the father had intended to give the amount represented by the check to his baby son as an outright gift, which was imperfect because the father didn't take any of the further steps to ensure that the amount represented by the check had actually passed to his baby. So the question now is, will the court perfect this gift by construing that scenario as the father declaring himself a trustee, holding that check on trust for the baby? If that's the case, then the baby son would be entitled to that amount represented by the check. If not, then no, baby's not entitled to it. Okay? So in this case, what do we know? Milroy and Lord says that equity will not assist a volunteer to perfect an imperfect gift. Why? Because from the facts, it's quite clear that the father intended this to be an outright gift. And as it is an outright gift, which was imperfect, since the father didn't take all the necessary steps to ensure that the money had gone to his son, equity will not construe it as a declaration of trust to ensure that the baby gets the money. Why? Because the baby in this case was merely a volunteer, meaning someone who had not provided consideration for this gift. Yeah. Second example is Richards and Delbridge. I think it was a grandfather here. He had land. It was a leasehold, so he owned some land, which he wanted to benefit his grandson. So what he should have done is actually execute a deed to transfer the property to the grandson, or to declare a trust, making himself a trustee. He didn't. He took the deeds, the deeds to this leasehold that he wanted to give to his grandson, and he wrote an endorsement on the deeds saying, I hereby transfer my leasehold to my grandson. And then he gave the deeds to the grandson's mother. Okay? So This gift is imperfect. Why? He hasn't actually transferred the legal title properly. We'll see how he should have done so later. Okay. So, imperfect gift. Grandson is not entitled to it because he hasn't actually transferred anything to the grandson. Will equity step in and construe this scenario, his actions, as him making himself a trustee, holding the lease, the land, on trust for the grandson? Because if equity steps in and places this construction on the scenario, i.e. that the grandfather, in doing what he did, actually intended to make himself trustee, holding the land on trust for the grandson, this trust is completely constituted. And if it is completely constituted, why? Because the legal title already lies with the grandfather, the trustee. But and if it was completely constituted, then the grandson would be entitled to the lease. However, again, just as in Jones and Locke, the grandson in this case was a volunteer, had not provided consideration for this gift, and therefore equity will not assist a volunteer to perfect an imperfect gift. So in this case, again, there was no gift and no trusts. There are some exceptions to this rule, which I know some of you are thinking, oh, that's really harsh. They should be, they should get what was intended for them and so on. So there are some exceptions which we'll look at not the next one, the lecture after this. Okay. Right. So I've talked about vesting property in trustee, but we haven't actually looked at the different methods. I'm sure some of you know this already. How do you transfer certain types of property? So different types of property have different formalities that are required in order for the transfer to be deemed effective by law. Let's look at them. The first is land or realty. Okay, realty or land. In order to transfer land or an interest in land, a deed is required. So it's governed by Section 1 of the Law of Property Miscellaneous Provisions Act 1989. And Section 1 talks about a deed, what a deed should look like. It should obviously be written. It should say it is a deed. And it should contain, obviously, what the settlor intended to transfer under this deed. It should be signed by the settlor and the trustees, and it should also be witnessed. Yeah, so there should also be someone who witnessed the settlor and the trustee's signature. Or it doesn't have to be trustees. A deed is to transfer property, so it should contain the signatures of the transferor and the transferee, as well as the signature of a witness who witnessed the transferor and the transferee signing. Okay? Shares. In order to transfer shares, it's not as easy as just if you have share certificates. Most people don't get share certificates nowadays. I think you just get a declaration that you hold this many shares. But if you do have share certificates, it's not as easy as just passing over the share certificates to whomever you want to transfer your shares to. What you, as the owner of the shares, have to do is to complete a share transfer form. The share transfer form can be obtained from the company these shares came from. And usually you go online and you can download the forms and you can fill it in. So you complete the share transfer form, and then you will deliver the completed share transfer form together with share certificates if you have them. You send them all to the company, and the registrar of that company will then register the name of the new owner and print out share certificates and send and deliver and post the share certificates to the new owner. Okay, so that's what happens. Completion of share transfer form, and lodging the share transfer form with the company, and the registrar will then make all the necessary changes, and this is how you transfer legal title to shares to someone else. Chattels or personalty. So if you want to give someone personalty, you want to transfer personalty to someone, a chattel to someone, how do you do that? Well, chattels, if it's one or two, it's fine. Physical delivery. You have jewelry that you want someone else, you want to make a gift to someone as a gift, just give it to them. I don't know what else, watches, iPads, iPhones, whatever, chattels, just give it to them. But what if you had a house full of stuff that you want to give to someone? You can't literally, one item at a time give it to them. So to facilitate it, what you will do is execute a deed. So a deed would it would be exactly the same as I've described earlier, Section 1 of the Law Property Miscellaneous Provisions Act 1989, in writing, signed by the transferor, transferee, and witnessed. And also, this deed of delivery of these chattels should contain a list and description of all the chattels you intend to transfer. That's how you would do it. Bills of exchange, checks. How do you transfer a check to someone? Now, I'm not talking about writing a check for the amount that you want to give to someone. That's not the same thing here. But I'm talking about, let's say you have just been paid. I know that checks are old-fashioned, but let's assume you've just won the lottery, and what's the name of the commission? Is it Camelot? Okay, you've just won £5,000 lottery, yeah, in the lottery, and Camelot has written you a check for £5,000, and you want to give it to your best friend. How do you do it? Well, what you need to do, according to the Bills of Exchange Act, you don't need to know this act, don't worry, is you need to endorse that check. So you need to endorse the check in the name of your best friend, saying, I endorse this for whomever, and they can then take the check to their bank, and they can bank it. Okay. I know that's not always the case. There are certain checks which says account payee only, in which case you can't endorse it. But assuming it's a check, it's an open one which you can endorse, then this is how you do it. But this part on checks, I know, is sort of quite out of date. No one uses checks anymore. But in case they do, this is how you do it. Okay. Now, equitable interest. Oh, this is our next lecture on formalities. Half of the lecture on formalities would be on how you transfer equitable interest. So what do I mean by transferring equitable interest? Let's say you are a beneficiary in a trust. You first, it means you're very lucky, and second, it means you have beneficial or equitable interest in certain property, i.e. the trust property. Okay, so but you don't want it, and you decide, I want to give it to my best friend. Right, how do you transfer your equitable interest? You are the one named as the beneficiary of this trust, not your best friend. So how do you, without going to see the trustees or the settlor to get everything changed, okay, the trust instruments and everything changed from your name to your best friend's name, how do you take control of your equitable interest and pass it to your best friend? Well, you do so in writing, and it's governed by Section 53(1)(c) of the Law Property Act 1925. And as I said, we will cover this in great detail. So that's all. I'll leave it there. What if you have money and you want to give it to someone? Well, you just give it to them. You deliver it. Delivery could mean that you actually deliver the money to them, that you have the money in your hand, you deliver it to them. But delivery nowadays can mean many things. You could, if you still own a checkbook, write them a check, or you could do it online. There are many different ways, PayPal, Apple Pay, whatever, you could do that. Okay, so delivery doesn't have to be actual physical delivery. Delivery could mean any of the means in which you can actually transfer money to someone nowadays. Okay, a chosen action. If you had a chosen action, how do you actually transfer it? Well, you give notice in writing to the debtor. What is a chosen action? A classic example, the only one really that you'll come across in this module is a debt. So someone owes you a debt. Let's say you have a friend who's always borrowing money from you, and they've just borrowed £500 from you, and they know that they know they have to pay you back at some point. Okay, let's say you then decide you don't want that £500. You have another friend who is more in need of that £500. So there's a chosen action there. Okay, there's a chosen action there. So you can tell the debtor, this friend who's always borrowing money from you, who now owes you £500, you can tell them, by the way, when you do repay that £500, don't pay it to me, pay it to someone else. So how do you transfer it? You can transfer it to the other friend, okay, the friend in need, by giving notice in writing to the debtor, telling them to pay the other person instead. This is how you transfer a chosen action. So a debt is a chosen action, and that's governed by Section 136 of the Law of Property Act 1925. And this concludes the lecture on constitution of trusts.